In this episode, Scott is joined by Professor Ignacio Cofone, Oxford's Professor of Law and Regulation of AI and a member of both the Institute for Ethics in AI and Reuben College. Author of The Privacy Fallacy, Harm and Power in the Information Economy, Professor Cofone's research examines privacy, fairness, and responsibility, focusing on how the law should govern new harms created by AI-enabled inference, prediction, and profiling. He and Scott explore surveillance, prediction, and responsibility while entertaining various real and hypothetical scenarios. Enjoy!
Thanks so much for coming onto the show.
Thank you for inviting me.
My first question is just about your background and interests. We obviously spoke a little bit before the interview. We were just talking, but could you give the audience just a sort of broad overview of your background, interests, and what's exciting to you these days?
Oh, sure. I'm currently Professor in Law and Regulation of AI here at Oxford. I work at the Faculty of Law and the Institute for Ethics in AI. Before that, I was working at McGill University as the kind of research chair in AI law and data governance. I'm interested in broadly the economic and social implications of AI and what they mean about how we should change the law and we could apply the law differently.
Okay.
And within that, I'm particularly interested in the role of regulation and the governance of information when we think about AI.
Okay. There's a lot here. And what is most exciting to you right now or in the past couple of weeks?
Exciting to me right now.
What are you wrestling with at the moment?
I'm wrestling with the concept of personal information.
Right.
And whether the concept of personal information is still serviceable.
This is like the Carissa Valise stuff, like privacy. I think she's in your institute as well.
Yeah. We're office neighbors.
Okay. So personal information of what kind? What constitutes personal information?
Well, that's the
question.
$1 trillion question. So right now for the law, personal information is mostly information that someone disclosed and that is identifiable. So in the EU and
what is disclosed?
Well, exactly.
Disclosed knowingly, we all agree to the T's and C's. Nobody reads them.
Well, disclosed or collected from, but crucially, it is very complicated to count AI inferences as personal information.
Yeah.
And in theory, they count, but in practice, they don't, and that's a big problem.
Okay. All right. We're going to get into all of this, but I want to move through this in order. To give you a bit of background on me, my current dissertation is looking at the public health response to COVID in the United States, and particularly in New York. I'm looking at sort of legitimacy fractures, the fractures in public trust, which arose during and after this public health response. So I know, this is going back a few years. There's a lot more information available now, but, in 2021, you wrote this article about Canada's, I guess was their app or their data gathering system, the COVID alerts, privacy promises, and surveillance risks. I'd previously worked on this in the Australian context, and now I'm looking at it in the U.S. context. But from a legal perspective, well, selfishly, I want to know about the U.S. But if you know more about Canada, you can go with Canada.
Okay.
From a legal perspective, how was data gathered and what was it used for in the response to COVID, either in Canada or the US, whichever one you feel you know better?
It's hard to answer that from a legal perspective because I think the question about contact tracing apps is a bit more...
So we're talking about contact tracing apps, not just like...
Oh, I thought you were asking me about contact tracing apps.
Well, in this article, but also like there was data being used, not just within the apps,
Right.
Data related from cell towers about how people were moving around, involuntarily
Right.
collected data.
So the U.S. question is a little bit more complicated because there are a number of frameworks that overlap because the U.S. doesn't have one comprehensive privacy law that just applies in the way that Canada has. So Canada has two large privacy laws that apply federally PIPEDA that applies for the private sector and the Privacy Act that applies to the public sector. And they're quite similar, but they do have some significant differences. And one significant difference is that the private sector statute, PIPEDA, does require consent as the only basis for data collection. But the Privacy Act, the public one, is a little bit more flexible. And part of that is a recognition that sometimes governments do need to collect or use data for the public interest, and that's okay. The GDPR, for example, also has that. The GDPR has 6 bases for collecting or processing information. One of them is consent, another one is legitimate interest. In the US, it depends on a number of things.
Like the jurisdiction?
Yeah, states have comprehensive privacy statutes, and then at the federal level, you have privacy statutes, but they're sectoral. So you have, for example, HIPAA that applies for health privacy, but health privacy is defined quite narrowly. So you might think, data about...
Well, that's a perfect example, HIPAA, because the idea of a vaccine passport, right? Like, then this is not private for people. So does it even apply?
Well, HIPAA mostly would not apply because HIPAA is for health information, where health information is defined, if I remember correctly, as something similar to information between patients and doctors or patients and healthcare providers. So if, for example, you have a Fitbit in the US, you might think of that as health information, but that's commercial information. That's not health information, just not covered by HIPAA.
Was Fitbit data being used to track who was at risk for COVID?
Not that I know, but they could have if they wanted, I guess.
Who's they? I mean, because HIPAA is private, Fitbit is private sector, right? So when you wear an Oura ring or you have a Fitbit or you have Apple Health, what happens to the data?
Well, it's commercial data. You're consenting to it being collected, and there are different provisions.
And they can sell it then to who they want, or?
Well, it depends on what's in the privacy policy.
Okay, but nobody reads these privacy policies, I guess.
That's well, I don't know.
So is there are there standards or a framework around this?
Where?
Around wearable health tech.
Where in the world?
In the US.
Yes.
And how is it governed?
It depends on the type of information because it depends on what sectoral you fall under. It depends on the state because it depends on what state law you fall under. And it depends on what's written in the privacy policy.
Right. Okay. Maybe people should read the privacy policies.
Well, it's
or at least run them through ChatGPT.
It's very difficult to read privacy policies. There was one paper that I like from Laurie Craner and Alicia McDonald from about 10 or 12 years ago that said that given the average number of apps and services that a person uses, if they were to read beginning to end of the privacy policies, it would take them 280 hours per year, which is a lot of hours.
Right.
And I bet that number of hours increase now that we use more products and the privacy policies change more often. So it's unfeasible to read every privacy policy from everything they use, and you shouldn't blame yourself if you don't have time for it.
Well, so why don't we just go back to 4 years ago, I suppose. What was this article about?
Oh, you think that I remember things that I wrote 4 years ago? You're very generous. I'm going to go off memory, but I might be incredibly incorrect. I believe... Are you talking
about... What drew you? Yeah, I'm talking about...
Which one?
COVID alerts, privacy promises, and surveillance risks.
The short policy report.
Yes.
Yeah, if I remember correctly, the short policy report was analyzing different options that Canada was considering about which contact tracing app to use, and examining whether they would pass what one could call some form of proportionality test.
And in the Canada response, I have not studied Canada. I don't know Canada very well. I remember the flashpoints, the truckers and the something about the going into the truckers' bank accounts. You were in Canada for?
I was in Canada back then, yeah.
So what exactly happened? The vaccine, the pandemic unfolded in 2 phases. There was the pre-vaccine. Non-pharmaceutical intervention phase, and then there was the post-vaccine phase. The truckers, if my memory is correct, there were some kinds of vaccine mandates, and people were unhappy about it. And then there was this sort of coalition of lots of different people who are angry about different issues, and they got into trucks and they drove to Ottawa? Or what?
Pandemic is a blurry time for me, and you're forcing me to remember the news, which I try to avoid during the pandemic because they stress me out. But if I recall correctly, there were a number of measures to contain the spread, some of them federal and some of them provincial, because health is under provincial jurisdiction in Canada. So, for example, the different lockdowns were provincial, but there were federal measures, if I recall correctly, about crossing the border that were relating to vaccines. And I think that's where the truckers were.
Crossing provincial borders.
I think it was to cross from Ontario to the U.S.
But that would be international.
Right. I think that's why they were...
Oh, there were restrictions that they couldn't do their business.
There were federal rules, and that's why they were manifesting in Ottawa and not in a provincial capital.
Right.
If I recall correctly.
Yeah, no, I did. You're asking the wrong person. So in the end, what kind of surveillance apps were used in Canada?
So Canada ended up making what I think was a very good choice, which is it ended up rolling out an app that was based on proximity through Bluetooth, not based on GPS, and that would keep most of the data localized. So people could choose whether to download the app. I can't remember the name. It could be COVID Alert or it could be something else. I can't remember. And I had it, and it would tell you whether someone near you had declared that they got COVID. But the communication around the app could have been a little bit better for two reasons. People were, I believe, or at least some people were a little too confident on what the app said. And so they were not exactly aware of false positives and false negatives.
Sure.
And they got alerts when they didn't need to because the app doesn't know where walls exist.
Yeah.
And when they didn't get alerts, they thought everything was okay, but maybe it wasn't. And the app didn't have enough uptake in the population to reach the threshold that would have made it most useful. I can't remember the exact numbers, but I remember a paper, there was some discussion around it, so I don't know if the paper was accurate, but I remember at least one paper that got publicity saying that the ideal is to get around 40% of the population, and I think Canada got 20-something% or around 30%.
I think certainly in the Australian context, and in the U.S. context too, again depending on the jurisdiction. But I'll just use this happened basically everywhere in Australia. But just to use the example of New South Wales and in New York, two states. There was a question about the extent to which compliance could be mandatory, or compliance could be induced.
By compliance, you mean downloading the app?
In the example of sort of contact tracing apps, yes, but or vaccine passports or getting a vaccine, the extent to which compliance was kind of socially induced. Like if you want to go to the pub, if you want to go to enter a mall or a grocery store, you show your vaccine passport. And it was, at least I think private businesses were, depending on the jurisdiction, I can't remember. Some private businesses may have been allowed to discriminate based on that, like to decide for themselves.
Yeah.
Whereas I think maybe in Australia, it wasn't that businesses were allowed to decide for themselves, but it was that the enforcement, in New South Wales, the onus of the enforcement fell upon the private businesses.
Okay.
So my question to you is, again, like from a kind of legal perspective, how do you approach steering, I guess you could say, steering people's behavior, inducing compliance with what you want the public to do with outright mandating it? I suppose you couldn't mandate that people would have to have vaccines, but you could strongly encourage them to. I know this isn't exactly what you work on. We'll get to the AI stuff.
Yeah, okay. I think I can't tell you about whether you can mandate vaccines. I think that would depend on the country. Some countries do mandate lots of vaccines. You probably couldn't mandate people regarding an app, but you could give them as many reasons as you can to do it if you make the app as safe as you can make it. I can imagine.
Why couldn't you force people to have an app? Because you can't force people to have a phone.
Oh, you mean,
Is this feasibly or ethically? Like,
I would think.
he said, everyone, when you need to have an app, we need to know where you are at all times.
Yeah, I think both feasibly and ethically it would be quite difficult to force people to have an app.
Okay, yeah, we can move past the COVID stuff. It's just something that's on my mind, I suppose, as I'm working on this project.
Unlike most people who are trying to put it past their minds.
I know. Well, that's the thing is COVID for a lot of people existed in a weird liminal space where sense of timing is really strange. People think that measures which were in place for actually quite a short period of time lasted for months or years, and you know, people like there's like a pandemic fog, a pandemic blur. Everyone's very eager to just like move forward. And I'm eager to move forward as well, and yet I find myself, you know, doing.
Well, but you're a historian; it's your job.
Exactly. My next battery of questions is about surveillance capitalism. Is a term that comes from, you know, Shoshana Zuboff at Harvard. Are you familiar with her work? And it's so you know, my first question is about surveillance capitalism, the public sector versus the private sector. You hear about companies like Palantir, or you know, lots of other private sector companies which are doing all kinds of things with data, and then often, you know, filling some kind of role for the government. You know, they're procurement processes. So how do we think about surveillance capitalism in the public sector and in the private sector?
I think when Shoshana Zuboff writes about surveillance capitalism, or when Julie Cohen writes about the information economy, the main concern is the private sector and how the economy is increasingly reliant on either information or on surveillance. The dynamic between that and the public sector is a related but not directly overlapping problem. The main problem, I think, of the relationship between the private and the public sector is not necessarily how we're not regulating the private sector in a way that corresponds to how the economy works right now, which is a problem, but rather that with different dynamics between the public and the private sector, the public sector can short-circuit some protections that we have through information that is gathered in the private sector that wasn't gathered before. And that sounded convoluted, so let me give you an example. In the US, you have the Fourth Amendment, and Fourth Amendment law through case law gives lots of quite specific rules about what the police can and cannot do without a warrant. And essentially, the police can, without a warrant, do investigations that don't breach reasonable expectations of privacy, but the police needs a warrant for anything that would breach reasonable expectations of privacy. So the police, according to case law, for example, can sit at a park and overhear conversations without getting a warrant, but cannot use thermal imaging to see inside of a house without a warrant. Those rules about what the police can and cannot do break down a little bit when the police can obtain much of that information from the private sector that already has it. So there was a large Fourth Amendment case called Carpenter, I think in 2018, when there was a number of, robberies, and the police got location from a number of suspects through cell phone towers that could triangulate the location from people without obtaining a warrant. And the case was, can the police do this? The police cannot follow these people we cannot put GPSs on these people without a warrant, but can can they obtain what is essentially GPS location through their cell phone provider? And the Supreme Court said no. Now, the Supreme Court said no for this case, but there's a universe of cases where a private actor can release information without a warrant, and that blurs some of the guarantees that people have about what governments can and cannot do to obtain personal information about them.
Well, how do you regulate this? As you said, this is a short circuit that's happening.
Well, one way to regulate it is by having case law that says that the police cannot so easily get information from private parties without a warrant, and that tries to set principles. Now, the difficulty is that the Fourth Amendment doesn't protect information. The Fourth Amendment protects types of evidence. For example, say that someone is suspected of committing financial fraud. The police cannot break into their home, open a locked drawer by force, steal their financial documents, and take it to the police station. But if the person is walking on the street and drops the same financial documents on the sidewalk in front of the police station, the police can read them. That's because the Fourth Amendment protects ways through which the police acquires information, not the pieces of information themselves. So it is a delicate balance when the way that
drops a bit of data by accident on their way to work.
Right. It is a delicate balance to try to have rules that extend to new forms of communication so that we are preventing what the Fourth Amendment is supposed to prevent, which is a generalized state of surveillance where people are, when people's information is collected when it shouldn't be, while at the same time giving the police enough tools to conduct the investigation that they need to conduct.
How do people give out data unknowingly? I think.
Ooh.
I think this is something that'd be interesting for the listeners and something I think about. We are constantly emanating data. It's coming off of us. Although you're giving off data right now, probably through your.
We are constantly emanating data. I'm right now giving data about my gender, my ethnicity, my approximate age, my
you have a
background,
wearable tech, your heart rate,
exactly.
Everything.
Oh yeah, I just mean to the people that are watching this podcast, let alone to everyone else.
Yeah.
We are emanating data through our cell phones. We have GPS location on. It is almost easier to answer in what ways people are not unknowingly releasing data, because we tend to think of all the data that we unknowingly disclose or all the data that is unknowingly collected from us, but we don't even think that much about all the inferences about us based on that data.
Yeah.
Just with something as simple as location. We all know that our cell phones have GPSs, and we all know that our cell phone providers have information about where we are based on that. Sometimes we see the history in Google Maps and we think like, oh, look at all the places that I've been. That's so cool. But we don't often think that that gets aggregated very easily with public information about where stores are. And that means that there's also information about what establishments we've been to. And that can be aggregated with location information from someone else. So it is easy to know who you were with, how much time you spent together, when and where, which all of a sudden starts disclosing a lot more information about you that you thought when
Plus
you were
your
thinking about
credit cards and tracking how much you're spending at each of these places.
Credit cards tracking your spending, and even when we think about inferences, we often think about immediate inferences.
Let's define inference.
I would call inference whatever information is not directly collected, but is probabilistically guessed based on information that was collected. And there's some very...
Give just a very easy example. You're, I don't know.
Yeah, who you spend time with.
Sure.
Or you might have inferred my approximate age when I'm sitting in front of you. You might have inferred my gender because I'm sitting in front of you. But inference can be a little bit more complicated than that. There are a couple of papers in computer science that show that in the US, you can infer people's political convictions based on their coffee orders, for example. Apparently, liberals order more lattes.
Okay.
I don't know what you're drinking in there.
Latte.
There you go.
What makes you think I'm a liberal?
It's just probabilistic. I'm not the one making the discovery. I'm just reporting the finding. And people's ethnicity can be inferred from their Spotify history. And that's just a couple of inference from one information point. If you start combining information points, inferences become endless. It's almost silly to think about privacy or data protection without thinking about inferences today.
There's a guy named Mark Fisher, not a legal scholar. You know Mark Fisher?
No, I don't.
Oh, I saw you nod. I was like, no, really? I'm
just paying
quite
attention.
obscure. Yeah, no. Mark Fisher was you don't even know what. I think he was an anthropologist. He wrote a book called Ghosts of My Past, and he came up with this theory that it was easier to imagine the end of the world than the end of capitalism.
Mm-hmm.
And this was like 20 some odd years ago.
Mm-hmm.
He was in London. He committed suicide years later. But he had this whole genre around him called K-pop, or K-punk, excuse me, not K-pop, not the Korean music, K-punk. It seems very hard to imagine an information economy without inferences on the one hand, but it seems hard to imagine the modern American economy, and all this, the global economies all over the world, without extraordinary degrees of personal data from everybody being used constantly in all kinds of ways, from the ads you see to the ads you see is the tip of the iceberg. This leads to really hairy ethical questions, like can we steer voting behavior? Can we steer the purchasing behavior? Whatever. But it seems impossible for me to conceive, well, maybe not impossible, but at least extremely difficult to conceive of our current economy without all of this personal data. Is that a crazy conclusion?
I don't think it is. I spent a lot of time thinking about the law, and when one thinks about how the law should react to the reality of inferences, I think it is less about should we stop them, because the answer is probably we shouldn't, and for sure we can't, even if we should, but rather how do we adjust the measures?
Why shouldn't we? You're essentially stereotyping about people. It's maybe not good.
Are you?
Yeah, you're whatever. I have this information.
You're whatever.
Yeah, I have this information about you, and so I'm gonna have assumptions about you because of that information.
Well, stereotyping is when one turns a probabilistic statement into a certain fact. But I think most of the private sector that uses inferences very much rely on them probabilistically.
Okay. So what is the case for inferences?
Oh, I'm not trying to make the case for inference. I'm just making a much more humble point by saying my main concern is not whether we should stop inference altogether, because, as you said, I find it hard to think about the economy without inferences, but rather how do we adjust the measures of protection that we have that were designed for a world before inferences so that they work equally well in a world of inferences.
Well, so I mean, I was at a panel with you may have been on the panel, to be honest, but it was with Ruth Chang and a number of other scholars whose names escape me. I think this was last spring, and they were talking about regulatory speed, right? And somebody asked a question about how regulation is always going to lag behind. So my question is, like, obviously some of this stuff needs to be regulated. Somebody needs to be paying attention, right? But because of the the pace
Yeah.
of of AI development, it seems like regulation is always going to be infinity years behind what the companies are doing. And so this leads to a question: how do you balance regulation with both individual responsibility and then also corporate responsibility? Like, yes, eventually you're going to need to write rules that reflect the world we're living in and not the world of 5, 10, 50 years ago.
Yeah.
Right. On the other hand, some of this stuff is not to say that we shouldn't try to, get a handle on how to regulate this stuff properly. But on the other hand, individuals and companies in particular, particularly AI companies, need to willingly, take on some of the responsibility, right? So I don't know, how do you balance this?
So
maybe you have a less grim view of regulation because this is what you work on all the time. I'm just I'm an armchair theorist here.
I think when people are afraid that regulation will always lag behind, they're thinking about only one type of regulation. And I think it is true that regulation will always lag behind significantly if we write it wrongly. But there's some forms of regulation that don't lag behind with technological change. Think of tort law. Tort law is one type of regulation that tells you when people are liable for the things that they do outside of contracts. Tort law was quite literally developed for horses and haystacks.
Right.
And it works relatively well for self-driving cars. I mean, we have some uncertainties, but overall it works quite okay.
Yeah.
The law of contracts works quite okay for a number of things. The types of regulation that don't age well are the types that try to be very specific about the technology or try to be very specific about prohibited and permitted behavior in a way that indirectly ends up depending on the technologies. So in the regulation of technology, in data protection law and AI regulation, there's this mantra to be technology neutral. The idea is you want to develop regulations that are not contingent on the technologies that you have right now, because otherwise bad things happen. One example of a really bad thing happening that I find quite entertaining is when the EU passed what was formally called the e-privacy directive, which is informally called the cookies directive. It was trying to regulate tracking, but instead it regulating tracking devices installed in people's computers. Guess what? There are lots of ways to track people without installing device in their computers. You can do fingerprinting, you can do header tracking, you can install a metapixel, and all of those things fall outside of cookie regulation, so the regulation wasn't very helpful. It wasn't technologically neutral. But the problem is that even if you try to be technologically neutral, you might end up formulating things that you allow or you're not allow that indirectly depend on the state of technology right now. So what you want to do instead is to be a little bit less precise on what exactly you can do and what exactly you cannot do, and a little bit more precise on what you're trying to protect. Because the values that you're trying to protect should remain stable with time as the technology changes. And those values should give you the flexibility to allow and disallow different things as time evolves based on that thing that you're protecting. The challenge there is that it forces you to agree on what it is that we're protecting, and people not only agree on that.
Yeah.
But that's why tort law works and data protection law doesn't work so well.
Right, whether for horses or for a contract. Is it unreasonable, or let me phrase it positively?
Yeah.
Is it reasonable to expect, or we'll go in the middle between positive and negative. To what extent is it reasonable to expect a degree of privacy in one's personal life in this day and age of data privacy?
I think it really depends on what you mean by privacy. Some people think about privacy as their individual control over their personal information. And if that is the definition of privacy, it is not very realistic to think about a degree of privacy.
What would you have to do? You would have to have no phone, no computer, live in the woods, do all your shopping with cash, or even then, where did you get
Probably,
the cash?
and even that might be ineffective. Because if we think about information probabilistically, then lots of probabilistic estimates about you are not based on information that is collected from you, but information that is collected from people around you that relate to you in different ways. And so even if you manage to buy a tinfoil hat and not have a phone and live in the woods and you disclose no information whatsoever, there will still be information indirectly about you from all the people that surround you and all the people that have commonalities with you that do not surround you, that have lots of opportunities for inferences when we have really cool machine learning techniques to do them. So that would be ineffective too. I think the better way to think about it is to think about privacy as a mechanism to avoid harm based on our data. And that is something that we can do while...
What is harm?
Well, that's a very good question. I think we should think about two different types of harms. We should think about material harms that could be consequences of bad data practices, and these could be being dismissed from work, being discriminated, having your credit card copied, having your identity stolen, voting for someone that you wouldn't have wanted to vote for. And we should also think about immaterial harms. And immaterial harms are when you're exploited through your personal information, even if we don't have very specific evidence of the concrete material consequences that are likely to happen down the line.
Example of the second one, of immaterial harms?
There's an interesting enforcement action brought in Norway that had a ruling from the appeal court that confirmed it a couple of weeks ago. And the enforcement action was because a queer dating app Grindr had a provision in the privacy policy saying that it shared information with third parties, and it used that provision to sell information about its user base to third parties, including their emails, their identifiers, their preferences in sex, and the files diverge whether that included their HIV status or not. It is very difficult to prove what consequential harms might happen to all of these people or to a subset of these people based on that. But I think it is relatively fair to say that an app that
sounds pretty material to me. I mean,
Well, the discrimination could be material, but the just selling of information is not a material harm. It's a loss of control.
Where's the discrimination in this, by the way?
No, if there is discrimination, that would be material.
Yeah.
If you think that some could face harassment, that would be material. But even if all of that was absent, one could think about exploitation. Because if one thinks about an app that makes money out of showing ads and selling subscriptions, that does not have a business model that primarily makes money out of selling user-based data, and users that have a certain expectation that because of the type of data, it will not be shared to a number of third parties,
right,
then what could think of that as exploitation? And the benefit of thinking about immaterial harms is that material harms often happen very far in the future. And they happen not as a consequence of a single data practice, but as a consequence of an amalgamation of different data practices. If you're ever unlucky enough to get your identity stolen, it will be very difficult for you to find the cause of the identity theft, because likely the malicious actor will have gathered data from many sources, and not one source that you gave your data to will be guilty of enabling the identity theft. So if we rely only on covering the material harms to privacy, then not only we end up underprotecting the immaterial ones, but we end up underprotecting the material ones too, because of all these causation problems. But that leads me back to the original question that you had, which is, what do you mean by harm, and what should we think about when we think about privacy if it is not control? I think a feasible way to think about privacy in a data-driven economy is to worry a little bit less about how much information is being collected and worry a little bit more about how information is being used, whether it's being used in safe ways and whether it's being used for the public good, or whether it's being used in exploitative ways that expose lots of people to lots of harms for private gain.
There is a lot to think about here.
Well, you're asking me complicated questions. I'm doing my best.
I am. I mean, to go back to the Grindr example, how many Grindr users read the T's and C's? I don't read the T's and C's on maybe some of the things that I should. We all sign subscription agreements to, Netflix, to our, to everything.
Yeah.
There is an argument to be made, I suppose, that Grindr put it in the T's and C's and people agreed to this.
Right. Well, that was the crux.
Knowingly or I mean, you have to click the box. I agree.
Right.
And then sometimes they make you show that you've scrolled all the way through.
Right. Yeah, as if that made a difference.
Yeah.
I mean, so there are a number of problems with that. So one is that no one has the time to read privacy policies, but
yeah, the 280 hours thing.
Yeah, but a deeper problem is that even if people did read all the privacy
wouldn't
policies,
understand it.
They wouldn't understand it, not because.
So what do you need a second bias that says I reviewed this with my lawyer?
Well, I think we need to rely on them less. And the key point there is that not that they wouldn't understand them because people are dumb or they don't have a lawyer, but rather that they wouldn't understand them because the privacy policies might describe a certain practice, but they often do not contain enough information to assess risks that are contextual.
Right.
So in the Grindr case, for example, the provision in the privacy policy, it says something like, we share data with third parties. Sharing data with third parties could be something as inoffensive as, we have a small server, we need to hire an external server, we send your data there and they keep it very safe and they're enough cybersecurity. Or it could be something as malicious as, we sell it to any third party that will give us money for it, even if some of them could put you at physical risk. And those two things are very different.
Physical, what is physical risk?
Oh, well,
in a country where it's
for
not,
example,
yeah,
or in a country that is Western and there's a group that doesn't like.
Yeah. Oh wow, I didn't even think about that. Some hate group will buy the data and
exactly.
then target
that
people.
Could happen.
How?
Well,
but they go through data brokers and it gets down the chain, and then you don't know, you sell it to the first person, but you don't know where they put it.
If you send it to undisclosed third parties, yeah.
This is dark.
Yeah, it is very dark.
Where's my data? When historically does mass surveillance? I mean, there's a lot of surveillance happening in the Cold War, all throughout the latter half of the 20th century. When does technology-enabled mass surveillance start to become the norm? And also, I mean, I think what people know that they're being watched, right? But they don't know that they're, by whom they're being watched, right? Is it private sectors? Is it social media companies? Is it the government? Is it a combination of two? It's obviously a combination of the two. But there is a sense in which I think people feel, on the one hand, ill at ease that there is a lack of privacy. And on the other, people have Alexa in their house, listening to them, in the most intimate moments of their life, having private conversations with loved ones, family members, whatever. I have a thing on my camera. I don't know if the camera is tracking my eye movements for ads or not. Maybe but when does sort of technology-enabled mass surveillance become a norm? Are we thinking post 9/11, sort of GWAT, global war on terror, or when does this really kick off? Because it seems the dragon now, it doesn't have one or two heads. It's got 10,000 heads.
Maybe.
So when does the 10,000 headed dragon start growing? Maybe before smartphones and everything. This is all we've been surveilling populations back the centuries. People were using surveillance for public health purposes, for I don't know when the census was invented, but to, get the idea of how many people are in your population. But yeah, I mean, this is something I wanted to ask you about.
I think maybe it was a little bit less of a moment where it exploded and a bit more of a gradient in which it increased slowly. If you ask me to think of one moment, in the early 1970s, I think in 1970, I don't want to give you an exact number because I'm probably going to be wrong. At one point in the 70s, the Nixon administration decided to come up with rules for this new thing called computers that might become popular at one point.
Yeah.
And that culminated in what are now called the Fair Information Practice Principles. And in the 70s, they were the broad things that you would expect, like be accountable, be transparent. And that little thing that were the basic principles for computers, got taken up by the OECD, by Convention 108, by the European Union, and now form the backbone of most data protection laws around the world. All of this to say that in the 70s they were thinking about it, but based on the number of things that you described in your question just now, you believe, and I think most people believe, that the way that information was processed in the 70s is quite different from the way that information is processed now.
Gathered and processed.
Gathered and processed and disclosed and used. Now, I don't know if there was a breaking point, but there has been increasing change that happens at an accelerated pace. And we certainly live in a different reality now than we did in the 70s or in the 80s or in the 90s or in the early 2000s regarding our personal information. Maybe if you encourage me to give you one specific answer, I would think the more widespread use of machine learning is one significant difference, because that allows you to make so many more probabilistic inferences. And that shifts the balance from the most risky and useful thing is how much information we can collect to the most useful and risky thing is how many inferences we can generate from information that we have.
When does machine learning start being used?
Oh, you would have to ask someone
in the mainstream. Well, how have you seen your field? You've got all these degrees. How have you seen your the field emerge even over the last 10 years?
Yeah, lots of this is not public. When I was doing my PhD,
it's public now.
Yeah, exactly. When I was doing my PhD in the early 2010s, it was already a thing.
Right. So, how have you seen, you're professor of regulation of AI. Now, how have you seen the development of AI and then also the regulation of it transform in the last 15 years,
We didn't transform much, interestingly.
From the legal regulatory perspective, it did. All the other stuff was transforming, but...
Well, but that's part of the problem.
But what are we even talking? Are we talking about laws, standards, frameworks?
Right.
Like... all this stuff is like cross-border, international, companies have offices everywhere. You have servers in Ireland, you have servers in India. Like, how do you even regulate some of this stuff?
So what's the question?
The question is, how have you seen, that's a good question. I have to figure that out. No, the question is, if you were doing your first PhD in the 2010s, it's 2025, it's, give or take 10, 15 years.
Uh-huh.
How have you seen the field develop? First you said not much, but I want to press you on this, because there's obviously enough to be a professor who's studying it.
So I was working on data protection back then because we didn't have a thing called regulation of AI back then, but we did start having a thing called regulation of AI in the late 2010s. I think the main lesson from the regulation of AI is that we tend to think of the regulation of AI as one specific statute that tells you, I am the statute that regulates AI, like the AI Act that says, I'm a general statute that would regulate AI. But AI is governed and regulated through every single body of law when they have rules that also apply to AI. And that is true of criminal law, contract law, tort law. I think it is especially true of data protection law. It's also true of IP. So all of these different fields of law evolved to adapt their rules or to try to adapt their rules to shifting social and economic situations when AI affected the assumptions under which the laws operate, either of how people interact or how the economy works. And all of these bodies of law try to protect the principles that they've been trying to protect in this new context. Separately from that, we started seeing a couple of years ago countries developing specific AI regulations. And now there is this big political tension about whether countries should have a specific AI regulation. Now, that is often framed as should we regulate AI or should we not regulate AI? But that's a bit of a distraction, because the key message is that AI is regulated in one way or the other, regardless of whether you have a specific statute, because all of these rules apply to AI. So the question is less about should we regulate AI, because to truly not regulate it, you have to abolish most of the law. And the question is rather, what are good rules for AI regulation? And then we can have a discussion about whether those rules are better placed in a specific statute, like the EU does, or they're better placed throughout different bodies of law, like the UK does.
And I mean, it's a big question of what is international law? How do you get different jurisdictions to cooperate and, enforce, getting the principles into practice through their own local frameworks?
That is generally complicated and is particularly complicated with AI. And it is particularly complicated with AI because many countries are afraid of losing the AI race. Many countries are afraid.
So they don't like regulation.
Yeah, because they think that any form of regulation is antithetical to innovation, when the reality is that only bad forms of regulation are. So it is difficult to get countries to coordinate because they are all afraid that if they set strict rules, they would dampen innovation in their own jurisdiction. A different jurisdiction will do the bad innovation anyway, and then they will win the AI race. So would it be better to have some sort of coordination? Probably. What's my outlook for achieving that form of coordination? Grim.
I mean, people talk about like international human rights law, which has always confounded me because at some point it is contingent upon the voluntary participation of different jurisdictions, right? There's there's frameworks and principles and things. Maybe human rights is an example, like AML checks and, KYC stuff. It's like, people will shop around. They'll go to the jurisdiction that is amenable to them, wherever it is. They're afraid of losing the race or losing out on business or losing out on whatever. Which it sounds like is maybe the same thing with AI. I guess the difference is this time, money laundering, not good. AI could be, an extinction level threat. That's like really not good. So
that I would say extinction is not good. But
is it an extinction level threat? I don't know. That's a whole huge conversation to have. I think it could be.
Good?
I think it could be, not that it good. I think AI could be an extinction level threat.
Oh, okay. I thought you were saying that extinction could be good, and I thought
no. I'm not saying extinction could be good. I said could.
Oh, I see.
With it, yeah.
Yeah, but I'm also worried about many risks that AI poses now, versus really catastrophic, low probability risks that it might face in the future. Not having good rules.
I don't know how low probability, but I'm going to ask you about prediction, but sorry, I don't mean to interrupt. Go.
It's okay. Bad rules for AI can lead to all forms of inequality, discrimination, lack of procedural rights, lack of transparency. And I think we should also be paying attention to those.
Okay, how do we pay attention to them now?
We pay attention to them. We pay attention to them by having rules that are keyed not so much on technological specificities that could change, but are rather keyed to principles that we want to protect. And so, for example, if we care about transparency, instead of giving very specific lists of aspects of a model that you want disclosed, when the models might change in 10 years, let alone 20 or maybe 2 years, set out the reasons for which you want transparency and the situations in which you want transparency, and then the implementation will change with time.
So what are some other principles? Transparency is one, I guess. Fairness another.
Privacy, ostensibly. Due process.
How does due process?
Due process plays out related to transparency if you're subject to either an automated decision and you may want to contest it, or you need to understand it, or if you're subject to a process that involves AI in some sort of way. There's, for example, one case in the US called Chubbs, where they had a cold case where they use a software to do probabilistic genotyping called TrueAllele. And TrueAllele will use new technology to tell you whether a blood sample that has an incomplete genome sequence is likely to be the genome sequence of someone else in ways that we couldn't match back then when some of these cases came about. And Chaps was someone that was convicted mostly based on that piece of evidence, and then asked for an explanation of how it worked, so that his defense lawyer could dispute any aspect that might not have worked. Now, the question is that something that you want transparency over? What are the values in play? We probably do want to use new technologies to have better evidence. How do we guarantee people right to understand the reasons for which they might be convicted while we use them?
I mean, to use an Oxford example, there was a student at Said, I don't remember the name or the details, but basically he was accused of plagiarizing something or using AI to do something, and he denied wrongdoing. And it was kind of funny. When he went to the panel, he was like, "You've all used AI, you just don't know." Every time he used spell check, every time he
right,
this and that. I don't remember the specific details of that case. But there's a problem in academia. I know universities are struggling to figure out how to give guidance or principles around the use of AI or generative AI in instructing students to what they should and shouldn't do, or what they can and can't do. And at least in this one case, I think one of the sticking points for this guy was that it wasn't clear to him what he was being accused of. I think the professor said, "This looks like it came from AI." And he said, "Okay, but where's the proof?" Right. Okay, so you ran it through an anti-plagiarism detection software. Let me see the code. And they're like, "Oh, well, we don't have the code." He said, "Well, but this is a hairy legal, ethical question." Right?
So that's due process. I don't know the specifics of that case, but
neither do I.
But those are the questions of due process. The questions of due process are.
So let's use do you teach undergraduates or you teach graduates?
I mostly teach graduates.
So let's say a graduate came, they say submit a final paper, they submit I don't know, they submit a written the piece of work, and you suspect that that it was not done by the student, or that they were relying too much on generative AI, right? Then how does this get approached? Or maybe actually because you're the dean, you're judging, right? Of this has happened. There's been a case where a professor suspects a student has used this. Professor comes to you, says, "What do we do?" It looks like plagiarism to me, or maybe they ran it through some software or something that maybe has false positive or false negatives, false positives.
Yeah.
How does this get approached legally? Strictly hypothetical.
Strictly hypothetical. Well, with the caveat that I'm not doing this as a prejudgment in case it ever actually happens.
Yes.
And I might have to make a decision with more information than the information that I have right now in this very comfortable couch. I would right now, if that happened immediately, say we are very bad as individuals at determining what has been written with generative AI and what hasn't been. And most of us are overconfident about our ability to detect what has been written by generative AI and what hasn't been. And most of the detectors that we have right now for generative AI are quite bad. And they have a large error rate, both in terms of false positives and false negatives. And not only they're pretty noisy, but the errors are not evenly distributed. And there's good evidence to show that non-native English speakers are mistakenly flagged as generative AI more frequently than native speakers.
Why?
I don't know.
Oh, I mean, I guess it's assumed that they would use it or to help them with English, or
No, papers have tested the generative AI detectors with text written by different humans
Yeah.
And it mistakenly flags as written by generative AI those that non-native English speakers wrote more frequently than it does for the ones that native English speakers wrote. I have a suspicion about why that is, but I don't know if it's for sure. Why not?
Because, I mean, intuitively, again, operating on some assumptions here, the assumption would be that the native English speaker knows, the English grammar, rhetoric, conventions, whatever, better than the non.
What are LLMs trained with?
Sorry?
What are LLMs trained with?
Well, everything. Right. It sources across
the internet.
Oh, so
who wrote most of the internet?
Non-native English speakers. Right. Okay.
LLMs write the way they write because the patterns that they replicate are frequent.
Well, interesting.
It's not that the type of writing is uniquely LLMs, it's that most people write like that. ChatGPT doesn't use M dashes all the time because it has a personal preference for them. It's because they're all over the internet.
I love M dashes.
There are great
long M dashes.
I was very happy when Altman tweeted that they fixed the problem and they removed M dashes from ChatGPT, because then I thought I can finally use them again.
But you would say, this hypothetical professor comes to you. What is your dean of equality and
right now, associate dean of equality and diversity. Equity and diversity. Yeah, but I don't deal with sanctions or investigations.
Well, in this hypothetical world, you do. It's hypothetical, So this is an equality issue. The student complains. They say, "I have been unjustly accused. I'm a non-native English speaker. I'm more at risk of being unjustly accused." Dean, help me out. This professor thinks that I've plagiarized. This doesn't happen at the graduate level, but this is more of an undergraduate thing, I suppose. But it would actually probably would happen at the graduate level, but undergraduates submit more papers, I guess, for the tutorial. So there's a student, they're accused, they come to you, and you say, okay, well, what do we have to weigh? We have to weigh the efficacy of the software that flagged it. We have to weigh the human error.
We have to weigh anything.
No, we don't have to weigh anything.
I'm sure there are procedures in place to handle this. By the people that handle them.
This is all new. This is all new, right? This is all happening in real time.
Generative AI is new, but complaints over student misconduct and standards of evidence are not new.
But this gets to what you said before. We need enduring principles which can withstand the rapid technological development.
Yeah, exactly.
So what are there things with AI generated content which are so new that we need to take into account these specific things about the technology?
I don't think we should be sanctioning people unless we have good reasons to believe that they did something sanctionable.
Well, of course, that's the principle. But what is a good reason? In this case, it's impossible to detect.
I think it's impossible to detect. I mean, someone might come with a way of detecting that I'm unaware of.
Well, you can quiz the student, and maybe they write a paper about I don't know, Pericles, and you say, "Who's Pericles?" Well, I don't know.
Yeah, that's one way to do it. There was a report that I saw recently that showed the frequency of certain words used in speeches in Parliament, and that some words that ChatGPT tends to overuse because they exist all over the web. You see timeline graphs with the frequency of word in different speeches across time, and you see that they're low usage, and then 1 year ago they jump.
Interesting.
So that's a good sign that LLMs were used, where you have a before and after, and you have one type of writing, and then all of a sudden you have a completely different type of writing because you get to compare. That's a better indication.
What about trends? People come up with hashtags, new words.
That could happen too,
but maybe not at the rate. I know this is all interesting to me. I want to close up by asking a few questions here. This is about prediction. This is another one of my research areas of interest.
Mm-hmm.
The question is about whether the law should treat predictions or inferences, probabilistic inferences about a person's future, right? risk scores, credit
Right.
risk scores,
Right.
behavioral forecasts,
Mhm.
profiling, whether the law should treat these differently from inferences about the present state, right?
Oh, I
Like,
see.
let's say that, you're surveilling. Well, I'm of the opinion you should. I'm like not big on surveillance, but like you're surveilling a population or an individual because there's like good reason to survey them, right? To the extent there can be good reasons. Now, because there's like an immediate present danger to something, versus this is the kind of guy who he fits the profile of someone who might become radicalized later. So we should, get on this now.
Like in Minority Report.
Yeah. Well, I've not seen the Minority Report.
Oh, you should watch it. It's about what you're asking me about.
Okay. Someone else recommended that too. But yeah, the question was whether the law should treat prediction or, credit scores.
Yeah.
If, we have someone who fits all the characteristics of an arsonist, should we preemptively strike, or what does that even mean? Could we preemptively de-arson them? I don't know. Like, hey, fire's bad. Should the law treat potential future risks different from current risks?
Yes and no. It depends on the type of decision being made. If we step back from AI, there's some types of decisions that are predictive, so they are trying to predict the future. And there are other decisions that are not predictive, that they're trying to say something about the present or the past. For example, when a parole board determines whether to give someone parole, they take into account whether they might flee and they might commit another crime during parole. That's a predictive decision. So an estimation about what the person might do in the future is epistemically appropriate for that. But there are other decisions that are not about the future, like whether someone committed a crime. Saying that someone was likely to have committed a crime is different to say that someone committed it. And saying that someone might commit a crime in the future is also different from saying that someone committed a crime. So an arsonist is different than a borrower in that sense, because the legitimate question that banks ask for borrowers is how likely is this person to repay the loan? But the question that we ask in criminal law is not how likely this person is to commit a crime in the future, but whether they committed a crime in the past.
No, we do. It's not in criminal law, but we do watch people who we
do watch people
who we think
to prevent crimes.
might commit a crime in the future.
So
this presents another legal
prediction
issue.
Could be a good reason for security measures, not a good reason for conviction.
And you can't convict them of something they haven't done.
That's what Minority Report is about.
Oh, really? Okay. We're gonna watch this.
Yeah. And one would have to figure out how to do the extra security measures in a way that is not inequitable if the predictions end up being inequitable.
Is equity one of the guiding fairness principles in AI that you were talking about earlier?
Well, I said equitably, but I meant fair.
Fair. Okay. I'm of the opinion that prediction has become a form of governance itself, a form of sort of algorithmic governance.
What do you mean by that?
What I mean by that is that predictive, sort of probabilistic inferences are themselves a governing rationality.
What does governing rationality mean there?
That's a good question. They are reason to make public policy choices.
Okay.
Just we make public policy decisions based on present forecasting.
Does that make them governing, or does that make them into reasons for governing?
Well, both, because the line becomes blurry. There are reasons for enacting policy, but they also the policy itself is also can be predictive.
Yeah. But sorry, you were about to ask a question, and I was interested by your claims.
No. Yeah. I mean, well, I want to ask my claim to you. Do you think prediction has become a form of governance, something closer to kind of political rationality than just a technical capability?
Well, it depends on what you mean by prediction. It depends on what you mean by governance.
Like
that's an underwhelming answer. I'm sorry.
It is. It's just like ex ante forecasting, right? Of some kind, which is used to create public policy decisions.
Yeah.
Right.
Yeah.
Do you think that's that is how a lot of public policy decisions are made? We're not looking back. We're looking to the future.
Yeah.
I mentioned to you before, I think this is empirically and normatively problematic.
Yeah.
But what do you think about this?
Well, we've made public policy based on predictions for a very long time.
Yeah.
The main difference is that we can make a lot more predictions now, and our predictions are a lot better. And so maybe more public policy decisions are based on predictions than they were before because we have more of them and they're better. Now, you might think that is just a quantitative change and a qualitative change, and we should discard quantitative changes and only worry about qualitative changes. I don't think that will be right, because sometimes quantitative changes are so large that they deserve the same attention that qualitative changes do. So do we base public policy on prediction? Yes. Do we did that before too? Yes. Do we do it more now? Significantly so. So should we pay attention to predictions? Yes.
And is that problematic?
It's only problematic if we don't treat predictions as predictions. It's not
that's what I'm sort of getting at.
Yeah.
That's I guess the Minority Report stuff. I haven't seen.
Right. Exactly. Yeah. It's a good thought experiment.
It's only problematic if we give predictions more weight than
they should have.
How much stock should we put into prediction if it's so much better now than it once was?
We should put a lot of thought into prediction.
Stock.
How much stock?
Yeah. How much weight?
It depends on the prediction, and it depends on the decision type. For decisions that are inherently predictive, we should put a lot of weight into prediction. For decisions that are not inherently predictive, we should not put a lot of weight into prediction. And it depends on how good the prediction is, what exactly we are predicting, and whether the errors of the prediction are evenly distributed or are unevenly distributed.
We don't know if they're evenly distributed or not because it's a prediction.
We can often test that. Oh, you mean predictions about the future, not predictions about the present? Well, we can often test them.
It's the same, though. The present is the future.
The present is the future.
That's my argument.
Well, sometimes we can test them. We can test how good an algorithm is at predicting whether people will repay loans based on the people that we did give loans to, and we see the repayment rate, and then we see the people that we did not give loans to, but someone else did, and what's the repayment rate. And that takes some time, but that does give us a good sense of the error rates of a system that we might still use, for example.
Is that fair, though, to make, lending decisions based on, algorithmic lending decisions?
Well, I think that depends on the algorithm.
Yeah. There's a lot to think about here, but I wanna just conclude on a lighter note and ask what I tend to ask guests at the end. What is your favorite book and favorite film?
Ooh, what a difficult question. What is my favorite book in general? I don't know. I can tell you about a good book that I read recently. I read a book called Chatter, but I can't remember the name of the author because my memory is terrible. But it's a book written by a psychology professor in a very accessible way about people's internal monologue. And I thought it was very clearly explained, and it didn't have a lot of filler, and I learned lots of things from it, so I very much enjoyed it.
Okay. And favorite film?
Favorite film? I don't know what's my favorite film all the time. But I saw a good one recently, but again, I won't remember the name because my memory is terrible. It had Olivia Colman and Benedict Cumberbatch. They were a couple. They were fighting over dinner. It's in the movie theater right now, and I can't remember the name of it. But it was very entertaining.
Okay. Well, thank you so much for coming on to the show.
My pleasure. Thank you for having me.